All right, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Yes, good morning all. As was discussed and agreed yesterday, the bench is sitting as a bench of two owing to the unavoidable absence of Judge Alexis Windsor, and as I say, which was agreed very helpfully by all parties yesterday. Yes, could we have the appearances? Defence, please.
Good morning, Madam President. Good morning, Your Honour. Good morning, colleagues. Good morning to the public in the gallery. Together with Mr. Ali Mohammed Ali Abd Al Rahman present in the courtroom this morning, we have Thomas Châtelet, who is our intern in the defense team, Madame Marcela Velarde, Mr. Mohamed El Rai, Madame Eva Kalb, who are assistant evidence reviewer, Mr. Ahmad Issa, our case manager, Audrey Matteo, our legal advisor, my co-counsel Yen Edwards, and myself, Cyril Lauchi.
Thank you. Prosecution.
Good morning, Madam President. Good morning, Your Honors. Good morning, everyone. Julian Nichols with Allison Whitford, Ed Jeremy, Claire Sabatini, Diana Saba, and Rachel Mazzarella. Thank you.
Thank you. And the representatives of the victims.
Yes, good morning, Madam President, Your Honors, dear colleagues. Good morning to everyone in and outside of the courtroom. The participating victims this morning are represented by my associate counsel, Anan Shah. Behind me, my case manager, Saif Cassis, and also behind me, our visiting professional, Charlotte Imhof, and myself, Nathalie von Wistinghausen. Thank you.
Thank you very much. Yeah, now, Mr. Leitch, before you carry on with your opening, I gather you want to raise a matter. Is it a matter that should be raised in private session?
Yes, I think it's better to go in private session to discuss it.
Yes, well, we'll do that briefly. Yes, private session, please.
We're back in open session, Madam President.
Thank you. Merci, Madame la Présidente.
Thank you, Your Honour. I shall continue with my submissions. In the place where I stopped yesterday afternoon, having hoodwinked the Office of the Prosecutor and its teams in directing their investigations towards a complete unknown, a pharmacist by trade, the Sudanese authorities have thus managed to accomplish the second feat of obstructing with impunity all the investigations of the defence of Mr. Abd Al Rahman. If Mr. Abd Al Rahman's fundamental rights in this trial were not at stake, I would take my hat off to them. It has to be said that the defence has been very isolated in this case. The Office of the Prosecutor is not likely to complain about a trial without the possibility of an investigation by the defence. Putting the safeguarding of its good relations with the Sudanese authorities for the purposes of investigations in other cases above respect of Mr. Abd's rights. That is its role. That is undoubtedly hardly compatible with a fair trial. But if the prosecutor were concerned, we would know about it. As for the registry, it is still not recovered from the revelation on the 14th of December 2020 in the public submission 231 of the defence of its failure since 2005 to negotiate an agreement under Article 4.2 of the statute, defining the legal framework for the court's activities in Sudan. I can only imagine the electric shock that reading submission 231 of the defence in the office must have caused. The proof is that more than 15 years after Resolution 1593, the Office of the Prosecutor rushed to Khartoum to negotiate a first agreement signed in January 2021, hardly 1 month afterwards. And the registry, for its part, negotiated another agreement on the 10th of May 2021. I can welcome the efficiency 1 month on one side, 5 months on the other to negotiate and sign these two agreements with regards to the 15 years that preceded it. Now, the registry has certainly not recovered from the defence's submission of the completely null and void nature of the agreement that was agreed in urgency on the 10th of May 2021, and all the efforts of the registry since have consisted of repeating that everything was fine with regards to Sudan with the court, even if at the same time the requests for visa from the defence were systematically ignored, and these requests for cooperation were without response. The registry, and in particular its external operations division, has demonstrated a guilty complacency with regards to the Sudanese authorities. The purpose of this complacency was to maintain the illusion that everything was going well and that the conditions were right for conducting a trial in a Sudanese case. They clearly were not. The defence noted this as early as 5th of October 2020 in its submission 174, and it has been repeating it without cease ever since. Breaking with its neutrality, the registry, and I'm speaking about the External Operations Division, in response, did nothing but maintain the opposite in order to allow this trial to continue against all odds. However, the facts are stubborn. They cannot be denied indefinitely. The facts on which the defence relies to demonstrate the deficiency of the legal environment in the present case and the lack of cooperation by Sudan are indisputable. Where we diverge with the Office of the Prosecutor, and which remains a debate, and which one day may have to be decided by the Appeals Chamber, is the question of the consequence thereof with regards to the fairness of the trial. But the facts for themselves are established, and I will mention 7 of them such that the public may take into account whether there's anyone who can challenge them. The first fact, Sudan is not a state party. Second fact, Sudan has not entered into a regularly ratified and published agreement relating to the court's activities on its territory under Article 4.2 of the statute. Third fact, Sudan has not enacted a national law on cooperation with the court as required under Articles 87.5a and Article 88 of the statute. Fourthly, contrary to Sudan's assertions, its July 2020 law makes no mention of the repeal of an offence of cooperation with the court in its national legislation. The fifth fact, Sudan's declaration, registered with the Secretariat of the United Nations on the 26th of August 2008, that it does not consider itself bound by any obligation under the Rome Statute, has never been withdrawn. It has never been contested. It has never been objected to by any other state, for example, the states who voted on the resolution. It remains, therefore, in force to this day, and it's very easy to consult it on the site of the Secretariat of the United Nations. The sixth fact, the Sudanese authorities did the defense the great honor in the communication of 12th of January 2003 in its response to its request to transcript documents to escalate them, and thereby definitively compromising for the defense any possibility of investigating in its territory. And the seventh fact, the same authorities have plunged Sudan since the 15th of April 2003 into a bloody non-international armed conflict which prohibits any court missions, has caused an almost complete breakdown in telephone or internet communications, making it impossible to implement the slightest witness protection measure on its territory, to which the court's victims and witnesses unit no longer has any access in any case.
Le constat de ces 7 faits
The finding of these 7 facts is sufficient to demonstrate that the conditions for prosecution and the conduct of a trial in the present case were not and still are not met. It is this consequence that we are in disagreement on. And it is on this consequence that the appeals chamber will eventually be called upon to rule. But I insist, we may disagree about the consequences, but the materiality of these 8 facts is not in dispute. However, denying these realities was not enough to maintain the illusion of procedural fairness. An explanation had to be found for the fact the defence was unable to make progress in its investigations. Since neither the deficient legal environment of this case nor the non-cooperation of Sudan could explain it, something else had to be found. Blaming the defence for the conduct of its investigations. Voila, that was the solution. Where visas were not issued by Sudan, the defence was blamed for its refusal to go on mission and its inability to seek alternative solutions, such as conducting its investigations from third countries. The Office of the Prosecutor did it well. Why not us? Blaming the defence as the sole explanation for the lack of progress in its investigations, compared to the investigations of the Office of the Prosecutor, is unjustified for at least 3 reasons. Firstly, the Office of the Prosecutor carried out multiple missions to Sudan from 2005 to 2023. Visas were regularly issued to its teams to travel to Sudan and to carry out investigations. The defence, for its part, was only issued with visas for a period of 30 days, during which it was able to organise one sole mission, and that was limited to Khartoum in June 2022. Secondly, while the majority of prosecution witnesses are persons from the Sudanese diaspora who have taken refuge outside Sudan, or groups of internally displaced persons gathered in IDP camps, supervised by non-governmental organisations, the witnesses of the defence continue to live their simple lives as Sudanese citizens in Darfur and are not accessible from the outside. Pharmacy customers, regimental friends, childhood friends, members of the tribe. This is the population that forms the pool of potential defence witnesses for Mr. Abd Al Rahman. Like him, they are completely anonymous. Most have never set foot outside Sudan and have no telephone. No non-governmental organisation is looking after them, and nor is able to act as an intermediary for the defence. The only way to identify and contact them, other than through the limited recollections of Mr. Abd Al Rahman and his personal contacts, is to go and find them where they live. And the defence has not been able to do that, ever. It has never been able to do that. The Sudanese authorities have prevented it. Thirdly, the Office of the Prosecutor had no less than 16 years to conduct its investigations and prepare its evidence before the start of the trial. There were ups and downs, but this is the amount of time from the start to the finish. Some of its requests for cooperations were met by the Sudanese authorities, and according to the interests and the strategy in particular, where it concerned giving or providing the prosecutor with evidence to accuse the scapegoat Abd Al Rahman, the Office of the Prosecutor furthermore obtained a 6-month postponement for the confirmation of charges hearing in the pre-trial phase in order to complete its investigations. And it did so after the confirmation of charge hearing. And here, I'm not talking about the astronomical sum of 39 million euros in the budget spent by the Office of the Prosecutor in the situation in Sudan alone since 2005 to 2022, or 2023. In 2023 must certainly be above that. This sum is mentioned in paragraph 6 of the report ICC ASP 216. Now, the defense, for its part, has never obtained more than a single 30-day visa, has only had an initial budget of 75,000 euros, once extended for its investigations, has received no response to any of its requests for cooperation, and has only obtained very limited extensions of time to conduct its investigations and prepare its evidence, even though its investigations were to take place since the 15th of April in Sudan, in which it no longer had access. The situation in Sudan comparable to all the other situations in which international criminal justice is applied? Are the risks that we see in Sudan and the difficulties investigating there, are they the same as the risks and the difficulties as those previously encountered in the former Yugoslavia, Rwanda, Sierra Leone, or in other situation countries of the court? Well, it would seem that, with the sole exception of the first years of the tribunal for the former Yugoslavia and the NATO bombings in Serbia in 1999, international criminal justice has only had to investigate post-conflict situations. Admittedly, these were not ideal. They were unstructured. My personal experience means that I knew Rwanda in 1995, Sierra Leone in 2005, Kosovo in 2008. But we were not in a situation of open conflict, as is the case today in Sudan. Until the opening of the situation in Ukraine, where no defense is at work, no situation before the court, not even Mali, not even Libya, is taking place in a situation of open warfare comparable to what Sudan has been undergoing since the 15th of April 2023. The court itself no longer has access thereto, and we would like the defense to investigate when it does not even benefit from any duty of care towards them, which I mentioned yesterday. So, faced with this simple and crude presentation of this sad reality, this comparison between, on the one hand, the time, the facilities, and the means given to the Office of the Prosecutor, with, on the other hand, the blame reserved for the defense, and the inflexibility in granting it the little time it has requested to continue its investigations. Would that situation stand up for a single second to an examination of the fairness of this trial by a reasonable observer? The answer is clearly no. In this case, the fairness of the trial has been definitively ruined by all, or tarnished by all the reasons that I have mentioned. The Chamber will of course not be in agreement with my analysis, and it is up to another chamber to note this obvious fact hereafter. It is a question of patience. The evidence cannot always be denied. It is too obvious. It will come. I shall move on to the presentation of defence evidence.
Malgré les difficultés que j'ai évoquées,
Despite the difficulties that I have mentioned, the defence has conducted its investigations, or it has conducted the investigations that it could. What the defence has been able to achieve in these conditions, and I weigh my words, is nothing short of miraculous. Firstly, it required an extraordinary combination of circumstances coming together at early July 2023, which enabled limited communication, but communication nevertheless to be established with one of the sites of interest for the defence investigation. Then afterwards, it took the relentless efforts of each and every member of the defence team, who I would like to thank and compliment individually for their continued dedication. And afterwards, it took the incredible dedication of the defence witnesses themselves, who were prepared to take incalculable risks to meet the defence outside Sudan, where in any other case before the court, which is normal, witnesses are contacted and met and looked after, taken care of in situ, where they are. None of this is part of the normal conditions of investigation before the court. Whatever the results that will be presented at the trial, they cannot suffice for the exercise of Mr. Abd Al Rahman's right to benefit from the time and facilities necessary to prepare his defence and to call witnesses on behalf before the court under Articles 67(1)(b) and (e) of the statute. The fact that the defence was able to carry out miracles, perform miracles, does not change this. The defence submits that miracles cannot serve as a standard applicable to respecting the right to a fair trial before the court. And the result of these investigations is that the brief registered and the submissions, the brief registered on the 2nd of October 2023 and the submissions that the Chamber have ordered be made today have been prepared at least somewhat blindly, in that the defence does not know even all of the evidence that it will be finally able, we hope, to present at trial. We have mentioned this in our brief of the 2nd of October 2023, and the consequences of the fact that we have to present the defence evidence without having all of it will be addressed in a more with an overview in the final brief of the defence. The ambition of the defence in presenting its evidence is to draw the Chamber's attention to the fact that the case before you is far from being as simple as the Office of the Prosecutor would have you believe. The Office of the Prosecutor has presented you with a disarmingly simple scenario that can be summed up in one sentence. A group of wicked Arab militiamen, known by the magic term Janjaweed, allegedly gathered together under the supreme command of an Abd Al Rahman, another magic term, called Ali Kushaib, to attack, pillage and persecute the fur population of Wadi Saleh and Mukja in response to a call for counter-insurgency issued by President al-Bashir. The defence will endeavour to shed some light on the grey areas of this simplistic scenario, which will reveal that the reality is somewhat more complicated than the Office of the Prosecutor would have you believe. Your defence will demonstrate that the Arab militias, confusingly labelled Janjaweed by their detractors, actually belonged to perfectly defined paramilitary formations: the Popular Defence Forces, Popular Police Forces, and Border Guards. Those persons recruited into these formations joined the reserve forces, governed by a law of 1982, the Reserve Forces Services Act, and they were then assigned to these different formations. In return, therefore, in return for their mobilization, they received clearly defined compensation or pay, which included compensation for possible injuries sustained in operations, wounds, for example, or, in the case of death, compensation going to members of the family. We spoke a lot about the confiscation of land and its reallocation. The allocation of land confiscated from the fur population was one element of the remuneration offered to members of these paramilitary formations. And it was coordinated and legally recorded within their administration by the Sudanese armed forces. These paramilitary formations were governed by a clear and perfectly organized hierarchy, with a command structure articulated at federal, regional, and local level. And in this hierarchy, the title of Abd Al Rahman had absolutely no place whatsoever. The title of Abd Al Rahman corresponds, for its part, to a tribal function. In certain Arab tribes, a group of people are given the title of Agids, and they elect from among them to coordinate their actions an Abd Al Rahman. Now, this customary hierarchy has nothing to do with the hierarchies in force within the Popular Defence Forces, Popular Police Forces, and Border Guards. Furthermore, the title Abd Al Rahman implies only limited, very limited authority within the tribe to which the Abd Al Rahman belongs. And it does not allow it, this title does not allow it to be exercise any command, outside the tribe, and even less within paramilitary formations within a well-defined hierarchy, similar to those I mentioned. The Office of the Prosecutor's case has made a simple caricature of this complex reality. Bringing it to light will be the first objective of the defence's presentation. Neither the materiality of the attacks nor the suffering of the victims will be addressed in the presentation of the defence's evidence. And there's a good and simple reason, therefore. That is because they are outside the scope of Mr. Abd Al Rahman's defense. The pharmacist in Garcilla had no information, no evidence about what happened or what did not happen in Kudum, Bindisi, Mukja and Delej. He was either in his pharmacy selling medicines, or alternatively, he was hundreds of kilometers away in a training camp. He's therefore not in a position to talk about the events described in the charges. All he can talk about, and what he can provide evidence about, is about himself and his lack of connection with the crimes charged. The defense therefore began by investigating what Mr. Abd Al Rahman was in position to tell us about himself, the pharmacist from Garcilla, who was not involved in any armed operations in Darfur in 2003. He had to find evidence of an uneventful life. Some would say a petite fille bourgeoise, if this very French expression could have any meaning in Sudan. This is evidence that is far less dramatic than the accounts of combat and atrocities that litter the Office of the Prosecutor's evidence. Evidence that is much more difficult to gather 20 years after the event because it's so insignificant. The evidence that the defense had to seek was that of non-events from 20 years ago. In the Sudanese version of the grim fairy tale that I mentioned yesterday, the defense has to give the account of life without the Sudanese version of Mr. Boubary, of Gustave Laubert. Another register, another challenge. Mr. Bovary is not the hero of the novel in which he appears. So who in this room can remember the non-events of their daily lives 20 years ago? We remember, or do we remember, how many times we went to the pharmacy in 2003 and 2004? On what dates? Was the pharmacy open or not? Who worked there? This is the kind of evidence the defense needed in this case. Undoubtedly, the nature of this evidence posed an additional difficulty for its investigations. Even if we concentrated on this subject, access to the evidence was prevented by the impossibility of going to the places where Mr. Abd Al Rahman had lived, primarily Garcilla and Rad el Berdi, where, of course, the people who had known him and who could testify to these harmless non-events would be found. Witnesses D02, D03, D04, D05, D06, D07, D08, D11, D28, D29, and D32 are witnesses in this category that the defense hopes to call to the trial. The defence also sought to clarify the general context of the events covered by the charges, which is, as said, is more complex than the OTP would have us believe. Who were these mysterious Janjaweed, these devils on horseback, defined nowhere by the officers of the prosecutor? Witnesses D16 and D17 will bring their first-hand knowledge to bear on this question. What is this no less mysterious title of Abd Al which the officer of the prosecutor defines only very succinctly and imperfectly? How was it designated? What was the authority of its bearer? If the defence succeeds in calling them to appear, witnesses D01 and D03 will give their personal knowledge of what this title actually means. Since the title, tribal title, Abd al because the title Abd al is a tribal title, and the Janjaweed militias were, according to the office of the prosecutor, recruited on a tribal basis, what was the case of Mr. Abd Al Rahman's tribe? Did this tribe participate in the counter-insurgency of 2003 to 2004? Could a member of this tribe have played a role as eminent and prominent as that attributed to Mr. Abd Al Rahman in relation to the operations of the counter-insurgency? The expert witness, called jointly by the office of the prosecutor and the defence at the start of this trial, I'm talking about Professor Alex Deval, has already answered this question in the negative. If the defence succeeds in calling them, witnesses D01, D02 and D03 will corroborate his answer with direct evidence from their personal experience. Were the crimes referred to in the charge criminal acts under the law applicable in Sudan at the time? Was there an obligation to obey an order to commit them? And what were the consequences for any offenders? Witnesses D16 and D23 will answer these two questions on the basis, firstly, of their direct personal experience, and secondly, on the basis of their academic expertise. Finally, a word about the partial alibi, of which the defence gave notice on 22nd of June 2023, as the defence states in paragraph 24 of its brief of the 2nd of October 2023, the limits encountered in conducting its investigations exacerbated by the ongoing armed conflict in Sudan mean that we have not been able to re-establish contact with witness D13, who is identified as the first and main witness in Mr. Abd Al Rahman's partial alibi. The continuation of this partial alibi is therefore conditional upon the future ability of the defence to re-establish contact with witness D13, to bring him to trial, to testify, or to identify other potential witnesses who could corroborate this alibi. The defence will, of course, keep the Chamber and the parties informed of further developments in relation to the partial alibi defence of Mr. Abd Al Rahman. You see no issue therewith. I propose that we now take a break. That will make it possible for my colleague Ian Edwards to start immediately after the break to present the first line of defence. Oh no, please excuse me. An error with regards to the time. We have until 11 o'clock, so my colleague Ian Edwards, with your permission, shall take over.
Yes, I think it is a bit early to take a break, Mr. Lachie, so we'll hear from Mr. Edwards.
Good morning, Madam President. Good morning, Judge Alipini Gansu. Good morning, Judge Alexis Windsor, who I know will be following us from afar. Good morning to friends and colleagues in and around the courtroom and to those in the public gallery. Most importantly, good morning to the people of Sudan who are watching from within or beyond the borders of that beautiful country. Salam alaikum. Your Honours, lead counsel has addressed you in some detail now about the difficulties encountered by the defence in carrying out its investigations. The fruits of our investigations, however, are much, much more meagre than we would like. At this stage in the proceedings, and in an ideal world, we would have wanted to be able to tell you about the many scores of witnesses that we had met with in Garcilla, in Yala, in Riyad el-Birdi, in El Obeid, and in Khartoum. In an ideal world, we would have wanted to be able to tell you today that we interviewed and took statements from many dozens of witnesses, and that we had then carefully and strategically sifted through those statements before making a final selection of the best 30 or 50 or 100 witnesses whose individual accounts, mutually coherent, complementary, consistent, corroborative, would be weaved together to create a rich and detailed tapestry on which the truth would be writ large. But we don't live in an ideal world. We have not been able to do what we wanted to do. Circumstances have not permitted us to place before you the evidence that this case requires and that our client deserves. We've had to do our best with the hand that we've been dealt. And you've heard already about the difficulties relating to non-cooperation from Sudan, save for one mission in Khartoum, the inability to go to Sudan, certainly the inability to access Darfur, and more recently, since the 15th of April of this year, a country on fire, essentially a failed state that is being torn apart by psychopaths who could not care less about the Sudanese people. We've not been able to get into Sudan, let alone Darfur. Meanwhile, there's been a mass exodus of those who are able to leave Sudan, both Sudanese nationals and foreigners. The embassies of the Netherlands, the United States, the United Kingdom, France, Canada, Switzerland, Sweden, the EU, I could go on, are all closed. There is not a single country whose travel advice is anything other than do not go to Sudan. And Your Honours heard on Wednesday and again yesterday from victims sharing their views and concerns. Your Honours heard about the dreadful security and humanitarian situation in Darfur from before the war, but certainly the situation has gotten worse since the outbreak of the war. Those victims' accounts very much chime with what our witnesses have told us. What is going on is nothing less than a catastrophe that the world's attention already appears to be turning away from. Now, against that background, of course, the impact the war has had on our investigations pales into insignificance when compared to the impact the war has had on people's day-to-day lives more broadly in Darfur. Nonetheless, it has undeniably made our work so much harder. But through hard work, tenacity, creativity, and not some small sacrifice, we have been able to meet with some witnesses, and that is what I now intend to address your honours on now. Almost all of the defence witnesses we propose to call knew Mr. Abd Al Rahman in Darfur. Taken together, their testimony covers a substantial period of his life, from the 1970s until the moment he surrendered to the custody of this court. These witnesses all know Mr. Abd Al Rahman well enough to be able to speak about him with considerable authority, including about any nicknames by which he was known. These witnesses are all important because they support Mr. Abd Al Rahman's case that he is not and never has been Ali Kusheb. This is what we describe in our trial brief as the first line of defence. It is in some respects factually the most straightforward aspect of our defence. A reminder, the prosecution's case is that the Janjaweed commander, subject to these 31 counts in the document containing the charges, is called Ali Kusheb. That Ali Kusheb is a nickname, and that Ali Kusheb's real name is Ali Muhammad Ali Abd Al Rahman. But from his first hearing before this court, his initial appearance on the 15th of June 2020, a couple of days after his surrender, our client made it clear that he is not Ali Kusheb. When asked by the single judge on the 15th of June, His Honour Judge Aitala, to introduce himself, our client said this, and I quote, "I can hear you. My name is not Kusheb. My name is Ali Muhammad Ali Abd Al Rahman. I repeat, Ali Muhammad Ali Abd Al Rahman. My name is not Ali Kusheb." His unambiguous denial that he is Ali Kusheb could not have been made clearer and could not have been raised earlier. Throughout the prosecution's case, the defence has challenged any and all testimony suggesting that Mr. Abd Al Rahman is Ali Kusheb. Now, and in the weeks and months to follow, the Chamber will hear positive evidence from as many witnesses as we have been able to marshal, all saying that Mr. Abd Al Rahman is not and never has been known by the nickname Ali Kusheb, that he is not and never has been Ali Kusheb. Witness after witness will testify that the only nickname by which he is known, by which he has ever been known, is Abu Nasser, a nickname arising out of the fact that his firstborn son is called Nasser. D1 is a high-profile witness from Riyadh al-Biadi. His family has known Mr. Abd Al Rahman for very many years. We expect D1 will say that he has never heard Mr. Abd Al Rahman refer to himself as Ali Kusheb, nor has he ever heard anyone call or refer to Mr. Abd Al Rahman as Ali Kusheb. The only time he will tell you that he heard the name Ali Kusheb associated with Abd Al Rahman was in the media and in the context of the prosecution's interest in arresting him. D2 similarly has known Mr. Abd Al Rahman as a family friend for many years, since childhood. He too will say Mr. Abd Al Rahman was never known as Ali Kusheb, only ever as Abu Nasser. D2 and others will come to court and will tell your honours that Mr. Abd Al Rahman was a simple man, not a rich man, who worked as a pharmacist in Riyadh al-Birdi and before that in Garcilla. That he was known as an honest man who could be trusted to mediate in local disputes. That he was often called upon by the community to do just that. D3, too, holds a position of some prominence in Riyadh al-Birdi. He also has known Mr. Abd Al Rahman for many years. In fact, since their days in the Sudanese Armed Forces in the 90s. He has never heard Mr. Abd Al Rahman refer to himself as Ali Kusheb. He will testify that no one has ever called or referred to Mr. Abd Al Rahman as Ali Kusheb. We will call D5. He will testify that he has known Mr. Abd Al Rahman for not fewer than 25 years, well before, therefore, the events of 2003 and 2004. He knows and will tell you that Mr. Abd Al Rahman had a pharmacy for humans in Garcilla, and that before then he had been in the army. He knows that Mr. Abd Al Rahman later joined the Central Reserve Forces. D5 will say, on oath, that he has never heard Mr. Abd Al Rahman refer to himself as Ali Kusheb, nor has anyone ever called or referred to Mr. Abd Al Rahman as Ali Kusheb. The only nickname by which he is known is Abu Nasser. Witness D4 gives evidence from a rather different perspective. He did not know Mr. Abd Al Rahman in 2003 or 2004. They only met in 2008. He worked with Mr. Abd Al Rahman in the CRF, and they spent many years together. D4 will testify that he never heard Mr. Abd Al Rahman refer to himself as Ali Kusheb. He will testify that no one ever called Mr. Abd Al Rahman Ali Kusheb or referred to him as Ali Kusheb. His nickname was only ever Abu Nasser. D4 will tell you that he only learned of any connection between the nickname Ali Kusheb and Mr. Abd Al Rahman through what he heard emanating from the court. Witnesses D6, D8, and D11 all share similar profiles, which I won't mention in open court due to concerns for their and their family's safety. Suffice it to say that two of these witnesses knew Mr. Abd Al Rahman from about 2004 until the time of his surrender to the court. But for his part, D8 has known Mr. Abd Al Rahman since the 1980s. Each of these three witnesses will appear before you and testify that no one has ever called Mr. Abd Al Rahman Ali Kusheb or referred to him as Ali Kusheb. They will say on oath that Mr. Abd Al Rahman is not Ali Kusheb. There's another witness who knew Mr. Abd Al Rahman from the 1980s, and that is D7. D7 is a retired military man who spent many, many years in close proximity to Mr. Abd Al Rahman. It's right to say that he will tell you that his dealings with Mr. Abd Al Rahman were less intense and less regular in the period 2003 to 2004. But nevertheless, he's able to say that in the years that he did know Mr. Abd Al Rahman, he never once called him Ali Kusheb, nor did he ever hear anyone call Mr. Abd Al Rahman Ali Kusheb. He too will swear on oath that Mr. Abd Al Rahman is not Ali Kusheb. D32 is a rare witness for us. He will testify that he knew Mr. Abd Al Rahman from Garcilla, including during the period 2003 to 2004. He'll tell you that he knew Mr. Abd Al Rahman for almost his whole life. We say that this gentleman, D32, is one of the best placed witnesses, if not the best placed witnesses, from whom this trial chamber will hear in this case, in terms of who Mr. Abd Al Rahman is, in terms of his ability to tell you accurately and in detail about Mr. Abd Al Rahman's day-to-day activities in Garcilla in 2003 and 2004. If Mr. Abd Al Rahman had ever been known by the nickname Ali Kusheb before 2003, D32 would know about it. If Mr. Abd Al Rahman had been known by the nickname Ali Kusheb in 2003-2004, D32 would know about it. And this important witness will tell you on oath that Mr. Abd Al Rahman had not been. D32's knowledge of Mr. Abd Al Rahman extends well beyond 2004 by virtue of his employment. That employment granted him access to Mr. Abd Al Rahman on a regular basis and for a lengthy period of time. Your Honours will in due course hear about this in detail, but as with other witnesses, I simply can't go into those details in public for reasons of that witness's safety and that of his family. But if Mr. Abd Al Rahman had been known by the nickname Ali Kusheb after 2004, D32 would know about it. He will testify that never once, in the entire time that he knew Mr. Abd Al Rahman over many years, never once did he call Mr. Abd Al Rahman Ali Kusheb. Never once did he hear someone else call Mr. Abd Al Rahman Ali Kusheb, or hear Mr. Abd Al Rahman being referred to as Ali Kusheb. He too will say that the only nickname he ever heard anyone calling Mr. Abd Al Rahman was Abu Nasser. Abu Nasser and nothing else. The first time D32, in common with many other witnesses in fact, heard the name Ali Kusheb was in connection with the defendant and in the context of his surrender to the custody of the court. D32 will tell you that he did not know how he could go about alerting the prosecution that they had targeted and charged the wrong man on hearing of his arrest. D32 will describe himself as a simple man of some modest education. He doesn't know how this court works. The machinations of an international court in the Netherlands, some 8,000 kilometers away from his home in Darfur, is, he will tell you, something that he does not really understand and something that he cannot relate to. What he can relate to, though, as a Muslim of profound faith, is prayer. And D32 will tell you that all he thought he could do is pray for Mr. Abd Al Rahman, and that, as an innocent man, God would protect him. Now, I refer to D32 as a rare witness. I call him a rare witness because he was and is, to date, the only witness we have been able to access in Garcilla. We would dearly have loved to call more witnesses from Garcilla, but it has, however, proved to be quite impossible. A number of the witnesses I have mentioned will also testify to say that during and after the attacks on villages in the Wadi Saleh locality, large numbers of Fur villagers left to seek refuge in safe areas elsewhere in Darfur, including in Riyad el-Biadi. A number of witnesses will testify that Mr. Abd Al Rahman and his family welcomed some of these displaced Fur into their own home in Riyad el-Biadi, providing them shelter, food, and human kindness. Now, at this point, I'd like to move into private session, please, Your Honour. Just for a few short moments, I apologise to those in the public gallery. It can't be avoided, I'm afraid.
Yes, private session.
We're back in open session, Madam President.
Finally, Your Honours will hear from a different kind of witness whose evidence will further undermine the prosecution's attempt to create a link between Mr. Abd Al Rahman and Ali Kusheb. Fiona Marsh is one of the UK's preeminent experts in the field of the forensic examination of documents, an area of scientific study in which she has worked and excelled for more than 40 years. She's been doing the job longer than most of our defence team members have been alive. Of most relevance to this case, she is an expert in the analysis of handwriting. She was instructed by the defence to examine what are purported to be two signatures written by Mr. Abd Al Rahman on two different documents. The first document, according to the prosecution, is a kind of a laissez-passer dated, or that dates back to 2003. And the first question signature is on that laissez-passer. Its ERN for the record is DAR OTP 02203921. And Your Honours may recall that it was mentioned or referred to in the evidence of witnesses P922 and P913. The defence's position is that Mr. Abd Al Rahman did not sign that laissez-passer. The second questioned signature is found at the end of what purports to be a handwritten note of an interview with Mr. Abd Al Rahman, an interview by Sudanese national investigators from November 2006. The ERN of that document is DAR OTP 0218-0231. The defence's position is that Mr. Abd Al Rahman was not interviewed by Sudanese investigators at any point. He did not write his signature at the foot of that note. We say that the signature was written by someone else and is a forgery. Ms. March compared these two signatures firstly to each other and secondly to a number of known signatures written by Mr. Abd Al Rahman. Fiona Marsh will come to court and she will tell you what her conclusions were. And I quote that firstly, there is very little, if any, similarity between the two question signatures, and there is no evidence to indicate that the two question signatures were written by the same person. Secondly, there is no evidence that the questioned signature on the laissez-passer document was written by Mr. Abd Al Rahman. And thirdly, that the November 2006 signature lies outside the range of natural variation that she found in the limited sample of known signatures examined, and that she is unable to determine with any degree of certainty whether or not Abd Al Rahman wrote the signature on the November 2006 document. Ms. March considered the following three possibilities for these findings. These hypotheses were as follows: that the similarities found between the known and questioned signature are purely coincidence, and the questioned signature on the November 2006 document was written by someone other than Abd Al Rahman. The questioned signature is a poor copy of the normal signature of Abd Al Rahman by someone familiar with his signature. Thirdly, that Abd Al Rahman wrote the questioned signature, but this signature lies outside the range of natural variation found in the limited sample of his known signatures that she examined. Ms. March, the court may feel, fairly states that she's unable to determine which of these alternatives is the most likely. But we would say that another way of putting it is, each alternative is as likely as the others. So, to conclude on this first line of defence, Your Honours heard evidence from witnesses over the course of the prosecution's case that Mr. Abd Al Rahman and Ali Kusheb are one and the same person. Over the course of the defence case now, you will hear from a number of other witnesses saying precisely the opposite. And those witnesses who will testify that Mr. Abd Al Rahman has never been known as Ali Kusheb, is not Ali Kusheb, say so from a far better vantage point than the prosecution witnesses. The defence witnesses, taken together, have known Mr. Abd Al Rahman longer. The defence witnesses know Mr. Abd Al Rahman better. And we say that the evidence of the defence witnesses, once you have heard it, no doubt, once it has been tested by my learned friends, we say that that evidence is to be preferred over any contradicting evidence called by the prosecution. The defence witnesses are for the most part in a perfect position to know if Mr. Abd Al Rahman is or was ever called Ali Kusheb. If he truly were Ali Kusheb, the defence witnesses we will call would know that he is, but they will tell you that he is not. And after hearing from the defence witnesses, even though, I repeat, nowhere near as many as we would have liked to call, and nowhere near as many as Mr. Abd Al Rahman deserves, you will place those witnesses' evidence in the balance and weigh them against the evidence of prosecution witnesses, who for their part say they believe Mr. Abd Al Rahman and Ali Kusheb are the same person. But we're confident that after finishing your careful analysis, you will conclude that the prosecution has not satisfied you to the high criminal standard, that beyond reasonable doubt, Mr. Abd Al Rahman and Ali Kusheb are the same person. And once you arrive at that determination, as we say you must, there will be no need to go any further. You will acquit, and you will be perfectly entitled to acquit Mr. Abd Al Rahman of all the counts in the document containing the charges. If, however, you find beyond reasonable doubt that Mr. Abd Al Rahman and Ali Khrushchev are the same person, that would not be the end of the matter, we say. There would then be what we have called the second line of defence to deal with. It is to that second line of defence I now turn, although I see the hour and this is a natural point to pause.
Probably is, Mr. Edwards, even though it's slightly early. Yes, all right. We'll adjourn now until 11:30.
All rise, veuillez vous lever.